This episode was sponsored by Property, the leading real estate agent for all real estate transactions with a comprehensive ecosystem. They combine highly trained experts with the latest technologies on an intelligent platform to provide clients, brokers, and service partners with risk-free, flexible, and simplified services. Learn more at property.com. That's property with an I.com.
That will probably be the most valuable thing I say today. Go to your lawyer with the term sheet. They've seen a lot of them, and they will probably add some of the things you didn't think about, and they will prevent some of the mistakes that can be costly.
Welcome to the Swisspreneur Show, a podcast about startup stories and learnings from experienced entrepreneurs. If you enjoy listening to our show, make sure to follow the podcast and leave a rating. And now, here's your host, Sylvan.
Stefan, a very well welcome to the Swisspreneur Show. It's a pleasure to have you as a guest today.
Thank you. I feel honored and privileged to be here.
Your LinkedIn profile reads like 3 LinkedIn accounts in one, basically. You are a founding partner of a law firm, you run Hooters in Switzerland, and you also sit on the board of a luxury watch retail empire. And from courtrooms to commercial kitchens, you've seen business from every angle. I think that's a fair statement. So let me start there. Are lawyers, that's your trained background, are lawyers actually good at business, or are they just trained to be a bit too cautious to eventually become entrepreneurs?
In my experience, there's all kinds of lawyers, obviously. But I would say, and it's probably not too risky to say, most lawyers are terrible businessmen. There's obviously exceptions to that, but generally, a lawyer, the training that you get as a lawyer is more towards avoiding risks and making sure nothing goes wrong. And it's not so much about taking risks. I think it separates some of the good lawyers to the not so good lawyers that, you know, they understand that it's about taking calculated risks and explaining also to the client where the risks may be from a legal perspective. Obviously, there's other risks than just legal risks. But it's not something that most lawyers feel very comfortable with, in my experience, when it comes to risks.
So it's a bit the opposite, so to speak, even.
Yeah, I think it's a bit of a different role, you know. I think even if you study economics or business, you're not really taught and trained how to deal with risks. Mm-hmm. I think that's more the entrepreneur, and we both know a lot of entrepreneurs, and a lot of them don't have an academic background, I think it's a bit of a different skill set that comes into play. Not everybody is happy and comfortable with risks. But I think lawyers can have an important role in identifying and avoiding risks. But usually they will not be the ones that, you know, will make decisions for you, will actually... that's the entrepreneur's job, you know, the decision taking, yeah.
So I wonder, in that sense then, I mentioned in the introduction, you run Hooters in Switzerland as one of your businesses. How does a lawyer end up running Hooters in Switzerland? That must be quite a story behind that.
Yeah, well, it's a long story, actually. Not sure we have time for all of it. It's not that I was looking for that opportunity, but Hooters is more like a thing of my early adulthood or puberty, if you want to call it that way. It was sort of the restaurant that I wished existed when I was younger. You know, obviously the girls play a role in it, but not really that much. It was really about having a bar, a beach bar type culture where everybody is welcome, where people mingle and mix, talk, and it's also international, not just local. Mm-hmm. You know, and it's a bit of I'd call it a bit of a dream theater, like a tacky, shiny world where you can actually just forget about your day-to-day problems and enjoy the atmosphere a bit. So that and how did we get to that? It's actually, it was a bold entrepreneurial decision at the time. It was basically due to a neighborhood dispute that we had with when we wanted to build a watch store, and eventually we and I'll cut the story short, we came up with the decision that we needed to send a clear message to the neighbors, do something that we would probably, hopefully make some money with and have fun with. And so, and it was also that there was legally no recourse to that, so it was not challengeable.
Mm-hmm.
And then I had this idea, we should have done the Hooters, earlier on. Now let's do it now, and that was like the perfect answer. So because our as you mentioned earlier, our family background is more watch retailing. I'm a trained lawyer. We've had some hotel operations in the past in the family, but we're not like trained restaurateurs. Let's say, no, let's do that, and actually, luckily it worked from day one. But I think we were more lucky than smart in many ways. But yeah, we did that in 2001, and we're still playing in Interlaken at least. Some of the other operations I had to sell. Not all of them did that well. That's
Okay.
the other part of being an entrepreneur. Not every risk pays off.
But it's fascinating because it looks like so many different businesses from the outside that you're involved with. So let's talk about lawyers in business. You said they're a bit trained the opposite direction compared to an entrepreneur. So from your perspective, what can realistically be expected from a lawyer in a business context, especially when you think about transactions, fundraising, or international expansion? What are the things that you can expect from a lawyer, and maybe also what are the things that you should not expect from a lawyer?
Maybe what you should not expect from a lawyer is and I would assume that most clients don't even want that, is that they take decisions for you.
Mm-hmm.
But I think they can be very helpful preparing decisions, that they can help you assess some of the key risks.
Yeah.
Then I think, in my experience, also very valuable is these transactions, they have pretty set standard of rules and procedures, how you go about it, how when you start, like with the term sheet, and there's the due diligence process, and there's drafting. And I think it's good to have someone with you that has done this a few times and knows how the procedure goes. There's a whole lot of psychology and emotions that come into it. The lawyer can help you steer clear of that a bit and maybe see more to what's actually at stake and through the emotions and all the other baggage that comes with it. There's also legacy issues very often, do you really want to sell the business or not? It's a family business. It's a good thing. So I think you can expect guidance there from an experienced M&A lawyer. Also, lawyers understand other lawyers because the other side usually has lawyers. Not all of them are always very practical and pragmatic. So you can help with that. And at the end of the day, you need to get along with the other side, and I think we can help there. And then last but not least, the lawyer is obviously responsible for the contractual framework to work. So that needs to actually it doesn't have to be overly complicated, but it needs to work, and then that's the lawyer's responsibility that everything is in place and working. Yeah. And also that the technicalities are in the right place, so that the shares are actually transferred. All these things I think the lawyers can do.
And often as an entrepreneur, you're used to do everything yourself, at least in the early days, right? Mm-hmm. And many entrepreneurs, they always expect that same behavior also from their lawyers. They want them to do contract, they want them to do risk mitigation, they want them to do negotiations. And I wonder, when are you better off with maybe one lawyer and just one person to help you with basically everything you need as an entrepreneur? And when does it make sense to go for a bigger law firm with maybe more firing power? I don't know. What is your experience there?
I'd start there that generally a good transactional team will consist of more than two persons. Obviously you need the principals there, so the buyer and the seller, and you'll need the lawyer for all the things I just said before, even if it's just making sure that the paperwork is in order. Usually there's a finance person involved. Sometimes the client will have that skill set, but often not, and not especially in a valuation type of way, in a transactional finance kind of way. And then definitely taxes play a big role. So sometimes the lawyer will have that skill set, but very often you'll need a very specialized tax expert in this. And I always tell the clients it's probably the best invested money, because if you screw that one up, it can be expensive. So there's always going to be a variety. And I think it may sound like it's expensive in the beginning, but if you pick the right specialists and also maybe a team that has done it together already a few times, it's cheaper and more effective and efficient than if you just have one guy. And obviously, the most important part of a transaction is always going to be, is it a good business fit? Does the merger make sense from a business perspective? Is the technical due diligence in order? Does it make sense that company A works with company B? Are there really synergies? More practical stuff, how the IT systems, is that going to work together and stuff like that? So, yes. And to your second question, when does it make sense to hire a big firm? I'd say not very often, but there is obviously scenarios where it makes sense. Usually what you'll get at a big law firm is you're going to get an incredible amount of speed and firepower, as you said, because sometimes things need to move swiftly and quickly. And then like law firm with 4 or 5 lawyers is just not going to be able to drop everything and devote all of their time to that one cause. Whereas a big firm, they can usually do that. They can say, okay, we send 10, 20 persons into battle for 2 or 3 weeks, and they can do that. Then also, some of them are very specialized and in certain fields where let's say the run-of-the-mill lawyer is not that experienced, so you'll find that there. But in my experience, usually, or even in my practice, we can do almost any transaction. We're like 5 lawyers, and we can get arranged and organized in a way for it to work. But for example, I used this example in the past all the time and never thought it would become reality. I said if UBS would merge with the Credit Suisse, we'd be the wrong boutique because we don't have the firepower. So, so I think you can almost always find for most concerns and legal issues a smaller firm that is as quick, quality is good, and will be a lot cheaper, which matters to most entrepreneurs.
Exactly. I wanted to say, because then you can also waste a lot of money, right? On resources that sound good, but you might not even really need them unless you really have a time constraint.
Yeah. I mean, if you're looking at a very technical issue where a guy of the top 5 law firms that does it on a daily basis, and he charges close to $1,000 an hour, it can be justified because he's probably 3 times quicker than another guy. The other question is, he gonna write down the correct amount of time? I would say most of them will, but he's gonna apply that same hourly rate for stuff that an intern can do, or a less experienced lawyer. So yeah, it's worthwhile considering, is that something that any or most lawyers or another specialized lawyer that maybe a smaller firm can do, or do we really need the big gun here?
Talking about payment, this is something I always see, right? Usually you pay by the hour. That's just the industry standard. But at the same time, while it's probably the best proxy that we have, it's still a bit flawed, right? Because someone with a lot of experience, they need way less time, but the value they create is so much bigger because they know exactly where to jump and go in the right direction, versus someone who doesn't have the experience. They need way more hours, so they're going to invoice you more. How do you best do the compensation part? Should there be a success fee in transactions like M&A or something versus hourly based pricing?
Well, it's a lawyer's dream, the success fee.
Of course.
In Switzerland, at least, there's certain limitations as to what you can do as to success fees, but there's way more wiggle room than is actually done in practice. The thing about the hourly rate is it's basically fair if it's done in a fair way, because you really pay for the time. And transactions are very hard to predict. Sometimes they take, I'd say a normal transaction takes anywhere between 3 and 9 months. And that's a big span already there. But what happens and at what speed is hard to predict. So if you do, and also sometimes not all the transactions make it to the end. So if you terminate the deal, you pay what you got the work for. If you have like a flat fee arrangement, which again, some people don't like paying the full fee when the deal doesn't go through, so you'll have these kind of discussions. And the other thing you said is true. I think, in my experience, you do not want to hire an overstaffing lawyer. I think the best control over a lawyer is hire one that has a lot to do already. So by definition, he's gonna just devote the time he has to the deal. And if he needs more time, he's gonna go the extra mile usually. But I think sometimes what happens is you pay for the education of younger lawyers because they get trained on the deal and all that. And you want to look at that carefully. How many people are going to do, what experience do they have, and how do they distribute the work among themselves. Sometimes they do blended rates, which can be or cannot be a good deal. But I think most entrepreneurs are wary of that, and will take a look. Yeah.
But it's really difficult to assess that stuff before you actually start working with someone, right? You probably can do some reference calls or something, but not much more than that.
At the end of the day, you're right. And I think the whole lawyering business is a lot about trust. But I really think, and it's my conviction, in the long run, that fair treatment and the fair billing does pay off. And obviously, have deliver the quality and be on time and all that. But I think most of them do that. What you also can do is obviously get a quote, get some estimates. Again, the estimates are not very concrete very often, but still you should have an idea of the ballpark you're in.
Right.
And again, from my experience, the best advertising I can get is a happy client that has done it and said, no, that guy was fair and he knew what he was doing and he helped me a lot through the maze of the negotiations and whatever.
I fully agree, because it's your reputation on the line, and that's the long-term game. I love
it.
It
is, and a lot of people have said this, you can always, it takes a long time to build a good reputation, and you can destroy it very, very quickly. Silly stuff like overbilling or mistakes. And again, mistakes do happen, but then it's also a question of how you handle them. Or do you own them? Or are you going to tell the client or not? But in my experience, it's fair play. It does pay off.
And I like what you said. I never thought about that, but it makes sense. I don't know where I heard it, but it was basically, if you want to get something done, give it to a busy person. Mm-hmm. So this also applies to a lawyer in that sense. I really like that perspective. I think that's a good tip to take away.
Yeah, because I think it'll force you to be efficient. It'll cut a lot of the bullshit. And I know, especially in lawyering, there's also a lot of documents that are there that are more for beauty than really necessary. Yeah. And like contracts, you can negotiate forever in theory, but at some point you have to be pragmatic and also be honest and say, look, no matter how long we negotiate, we're never going to cover all these scenarios and eventualities that might come up, but let's try and do what is usual, like is likely, what really fits the transaction and the clients here. And also the other thing I tell the people, look, the most important part about a contract is the counterparty who is on the opposite side, because while you do need a good contract and it's worthwhile doing them well, there's always going to be a point that you didn't think of, and then you need to sort of, it's like a bit of a marriage, you need to sort of be able to talk to one another and work out a solution. That is at least as important as what is in the contract, actually. Yeah.
Definitely. Yeah. We're already in the middle of it. I want to talk about a few legal pitfalls. You have seen so many different businesses, contracts, etc. And I want to talk about a few of the legal pitfalls that founders still face or even make mistakes today. One of the first things is always, when I start a company, I can do a GmbH, I can do an AG in Switzerland. And many say, okay, let's go for the GmbH because it requires less capital. It's otherwise very similar. Is that a mistake that is often made early on? Would you recommend to go for an AG always, if possible?
In the long run, probably yes, would go for the AG. But then again, you said it yourself, the differences are not that big. I would say the biggest difference really is when you have a GmbH is, everybody sees who the shareholders are. It's public, whereas in the AG, the Société Anonyme, that is in the shareholder ledger, which is not public information. In the beginning, I think that doesn't matter that much. And, I think a GmbH can go a very long way. You have similar advantages. The AG is cheaper, as you said. And should you get to the point where you really need an AG, but that's like really, really far down the road, it's not that hard to convert it into an AG. But it's going to take time. It's a formal procedure.
Mm-hmm.
And also what some people not always realize is that the money that you throw up for the founding of the AG, that you can actually use. It's just
It's
the course. The problem is do you have it in the beginning or not? Or you want to, can you wait for that period or not? Yeah, I'd probably go with what you're more comfortable with and what your means allow. That I don't think that's a big mistake in practice.
Then often when you set up a company, founders like to keep things pragmatic and simple, and that often also means skipping contracts. And I wonder if there's only one contract that you say, this is a non-negotiable. You have to do that when you start out as an entrepreneur and found your company. What would that be? What's your number one non-negotiable contract that every founder, every entrepreneur should fix?
Allow me two answers to this.
Sure.
I think, and that the first one is really if you're several founders only, obviously, I think you need some kind of a shareholder agreement. That doesn't have to be very, very complicated, and it's likely to change over time as more parties get on board, especially if you get investors or third-party financing. But good shareholder agreement will govern what happens to the shares. Should one guy want to leave or the other founders don't want him anymore, these kinds of things that make sense, because otherwise it can be very painful too. And I think it's in the interest of the company, which should be at the heart of all of the founders. So I would really invest some good time and money in that. Having said that, the shareholder agreement is a very complex agreement, and not even for lawyers. A lot of them don't understand all of the details. It's a very specialized matter. It's worthwhile consulting with a specialist there to get something, and it needs to be tailor-made to your company. And a shareholder agreement for a company with 80 shareholders is not going to be the same as the one for a startup.
There's no copy-paste template, basically.
Yeah, a lot of it will be copy-paste, but not all of it. And I think the 20% that is tailor-made, they matter. So that's definitely worthwhile. The other one, and again, that doesn't even take that much time and money, is whatever contract you have with your clients.
Mm-hmm.
You're going to have clients if you have an enterprise.
Hopefully.
Yeah. So it's some business models is not as important. For example, when we were in our family business in retail, you don't have written contracts. People are going to shop, they pay, they get the merchandise. But if you have like an IT enterprise or whatever, then it's worthwhile making sure you get a good template that actually works and is enforceable if it needs to be. So that is usually is a few hours, and you can fix the mistakes that are in there. And otherwise, they can be costly when transaction time comes or when something goes south with a client.
Right. I think it's really important because you have a great perspective here of you want to have the house in order for the time, which will be probably 5 to 10 years in the future, when you want to sell the company. And it will be difficult to go back and it's possible, but it's a lot of work and sometimes not even possible to go back and fix the stuff.
And contractual work is like you have to go and change every contract, at least the ones that are still valid, and if you have 200 customers, it's a nightmare. You're going to just spend a lot of time on the phone then explaining. Usually you don't want to explain them that you're in a transaction at all, so it can be tricky, that bit. So get your contract work in order there. Also, share transactions. That usually haunts a lot of people when transaction time comes, the title chain thing, because a buyer wants to know does the seller really own the shares?
Yeah.
And usually you have to go back from scratch and explain how the shares got to the seller now.
Right.
And if that's not in order, that can create a lot of headaches in transactions.
That is easier in a GmbH in that sense.
Yep, because that's public. That is definitely one of the advantages. But even there, mistakes happen sometimes. Yeah.
This episode was co-produced with EO Zurich, a branch of the Entrepreneurs Organization. EO is the world's only peer-to-peer network exclusively for entrepreneurs. It helps transform the lives of those who transform the world. On May 6, 2025, at Europaallee in Zurich, EO Zurich will be hosting the Entrepreneurs Summit, an event by entrepreneurs for entrepreneurs, focusing on the topic of loneliness in the startup world. Expect high-caliber keynotes and open discussions about the difficult personal situations of some of Switzerland's most successful entrepreneurs. There are 150 seats available, and the event is open to both EO members and to outsiders who fit the EO criteria. Head on over to entrepreneurs-summit.ch to learn more.
About the contract with the customers, there I have maybe a funny or a very naive story to share. I'm curious what you think about it.
Shoot.
The first startup that we had, we knew, okay, we need to have contracts. So we did exactly that. We hired a lawyer. And then they wrote us this 4-page contract. We were working with gyms back in the day. So very classic small businesses in Switzerland. And then they had these 4-page contracts with every possible thing defined in very small font.
Yeah.
So I then went on sales meetings and I saw the gym owner enthusiastic, wanted to join and sign the contract right away. Then I showed him the contract and I said, whoa, okay, I will read through that. I will get back to you. And we were never able to chase them again. I said, we have to do something about that. And then I just sort of kicked out everything and just summarized it on the one paper, referring to the general terms and condition and just do the basic. What plan are you on? When do you start? What's the parties? And then that worked and they signed it right in the meeting. Is that a good way of being pragmatic, or was that just me being very naive because I probably left out very important stuff?
I'd say that depends a bit on the industry. 4 pages doesn't sound to me like it's a very long contract. And okay, but if it's all in fine print, I think the fine print is probably more of a problem than the length of the thing. A good contract doesn't have to be very long, especially a lot of the boilerplate stuff that you have in the end. In Swiss law, at least, you can skip it. Yeah, keep it to the important stuff. Some businesses and some contracts are more adaptable or receptive to general terms and conditions. You can do that. It's hard to generalize the answer, but yes, I would agree. Keep them as short as you can, the contracts, and make sure. And very important, it should be written in language that you as the entrepreneur understand. If it's no good to you, if you cannot explain it to your other party, and simple, good language goes a long way.
Because then you also think about the enforceability, right?
Yes.
That's also very important. That's why you have a contract sort of in the first place, that if everything goes south and the relationship breaks or someone doesn't hold up to the contract, you have something that you can take to a court potentially.
Absolutely. Mean people, but I think they're right. They have a point to a certain extent. Say, in a good relationship, you don't need the contract.
Right.
And in a bad relationship, it's not going to help much because it's easy to find a way out of it somehow or to make a good argument. But at the end of the day, it's like your insurance, and you set up the basic rules of the relationship, and you want to make sure that it's as enforceable as possible. Obviously, not all enforceability depends on a variety of facts and circumstances you cannot all control, but you want to optimize it to that extent. And so if there's a disagreement, you say, look, this is what we agreed upon.
Right.
Okay. And then write it up in a way. Also very important, at the end of the day, the judge is going to make the call about what is important or not. It's not the parties, and whatever you guys understand as a party, it needs to be written down in a way that a judge who is a lawyer by training as well, who usually doesn't know much about your business, understands. And so make it out of this perspective.
No, that's a good tip. You mentioned the shareholder agreement as well. I also think it's probably one of the key agreements that you absolutely should make. And often you also then are confronted with the question about equity. And equity is very often emotional, right? Some people feel they are more important to the business than others, so they want to have more equity, etc. So I know it's not one size fits all solution, but founders often give away shares way too early and sometimes even too much to people who don't contribute that much to the business. So what's the smart way to think about equity? How much should give away? Who should get equity? What is your experience there?
I fully agree with what you said in my experience. And I think that's one of the greatest wastes of time and money is very often we'll meet founders that want to, the first agreement they want to do is the ESOP. I say, look, guys, you're at the beginning. You're thinking about exit already, which is not wrong, but you have more important stuff to take care of. And I'm with Warren Buffett here, and I think as an entrepreneur, your share, your stock should be the most valuable thing to you. So be very careful who you give it to.
No.
Giving shares away means you'll have more people at the table with an opinion, with a right to air their opinion, with a voting right. It's a discussion we have very often in our practice and also within EO, where we're both a part of. I think, in my experience, to sum it up, I think you should ask yourself 3 questions before you give stock away. First of all, is the person who should receive the shares willing to pay for it? So by no means give it away for free. It has to be a big decision. They have to have a skin in the game. They need to be at risk. So
it has to hurt when
things go wrong. Exactly. Yeah. So there's no free lunch. You want to be a shareholder, fine, but then because all the other shareholders they put some money or work or both into it, so that has to be at par with them. So again, it has to be a big decision. Secondly, I would say whenever you can, give money and not shares. Give shares away then when you will acquire something in return that money can't buy, really. Like if it's going to enlarge the cake for all the shareholders, the company's going to get better. It's a strategic value that gets, there's a shareholder that has a skill set no one has, or has contacts no one has. It's going to make it better for everybody. Otherwise, I think cash is the better solution. Okay. Very often, I think a lot of the founders want to give shares because they don't have cash. But that's a bit of a dilemma that they face. But I would hold off as long as I could. And number 3, not less important, only give shares to persons that are also willing to contribute when things go south. You don't need fair weather shareholders. You need people that will weather the storm and will actually step up. Obviously, they don't have to step up as much as maybe some of the more potent shareholders, but that are in proportion to their shareholdings are willing to put more means in and can do that. So then you have a good shareholder base, in my experience. So running around and giving shares away for free and to everybody, I don't think is a good plan. What we very often, when that conversation comes up, I'd say 98% of the cases, they end up not giving shares away. To be fair, also, very often, it's even more true with options, but also with shares, they're not that valuable to the small shareholder. I mean, what you're going to do with 5 shares of 10,000 in a startup or even in a bigger company. So people think, going to get really rich with these shares. I'd say in 80% of the cases, you're going to lose the money.
They go to zero.
Yeah, exactly. Yeah. So I think it's a bit of a blinding exercise very, very often. Yeah. And it's not really that fair to the shareholders. Maybe yes, when the company starts doing better and has been around and you can tell, okay, it's going up, then it's a bit of a different story. But very often we see a lot of disappointed faces in these kind of scenarios. And I haven't even started talking about taxes, what that means, the shares, which is tricky and complex as well. So again, don't start off with that. You have other things to worry about in the beginning, and later on, then do it the right way.
I often also feel that I get a little bit of shares. I get some phantom stock options, for example. It's also a means of, yes, I want to participate in your success, but I also don't want to fully commit. And that's a bit like, well, if you cannot fully commit and put money on the table, you probably shouldn't be working with me as a shareholder.
Exactly. I think phantom stocks are a good means, but again, it has to be applied in the right way. I think it's and very often when we start that discussion with SOPs, we end up with phantom shares. I think if it's a good means if people don't have the means to buy the shares, but for whatever reasons, as shareholders, you want some of the employees to participate in the course of the business if it gets better. And that, at the end, you end up paying money. So I think that's fair. And if done in the right way, there's limit. But again, it doesn't have to be structured in a way where they're not at risk. So usually, they'll come off a part of the bonus or their compensation. Right. So it should cost something, but I think that is fair. And the shareholders that really fulfill all these prerequisites, I said, they still control the company. But if it goes well, they're happy to share. So I think it's a good intermediate tool in some scenarios, yes.
At what stage does that become relevant? When should a startup start thinking about the phantom stock options? Is it only once you have hit a certain growth trajectory because you say, okay, now we need to hire way more people, we want to grow like crazy, and that can help you do that? Or should that already happen earlier?
It's hard to generalize, but I think it doesn't make a lot of sense unless you have some pretty steady revenues and you have a bit more than hope, some perspective that it's actually going to increase and these persons are going to contribute to that increase. So it's hard to say, but first 2 years, I think it's probably not much of an issue. And once this stabilizes, but you need revenue, you need profits for this to be well done. Yeah.
That's a good guiding principle, I think, because your job as a founder in the first 2 years and forever basically is to build the right product and to make revenue and grow the revenue. Yeah. You have enough work to do there already.
You have a business model to prove.
Exactly.
And that's not easy. It's a hard job. And the focus on that. And if you have happy customers, and then you've proven, okay, and it works. The business model is good. It generates profits. And it can be scaled in a long-term way. I think then you can start worrying about that. But and then let's keep in mind, I don't know the exact percentage these days, but I think 60% or so of the companies after 3 years, they're no longer in existence. So keep that in mind too.
Exactly.
When you
that's because they don't succeed at this first task, basically, probably. When we think about giving away shares, no matter in what way or form, how much percentage should you give away to your key employees of all levels, like your management outside of the co-founders, but also important individual contributors of your company?
Yeah, it's hard to generalize. You very often hear 10%. Honestly, I think the majority, that would be my only set rule. They should always have the final say on everything. Yeah. I think that can be one person that is really big wig there, that has maybe it's 3 founders. I don't believe in models, especially when VCs come in or other investors, where founders lose the majority, because then it can go in very funny ways sometimes. Yep. So they should have the majority. And then I would say it depends a bit on the employee and also on the business model. I mean, if it's a business model that depends a lot on the employees, you're probably going to need a lot of shares. Let's say you have a big distribution network with a lot of salespeople that are key to your model, then you probably need more shares, and you need to keep these guys happy, right? Because a good salesperson will get a job any day, anywhere. So if it doesn't, if let's say it's more of a software company that has a great software and then it's easy to sell, then maybe you don't need that much, but maybe you have some key programmers, but then it's less. And then also we can add on to what we discussed beforehand. If some of these persons are actually worthy of being real shareholders, then maybe you need to give some away of yours. So I'd say it can be anywhere. And also, if you have third-party financing, they will want some sometimes.
Of course.
So anywhere from 0 to 40% is probably going to be, it's a big spread, but depending on the model and the structure.
I think it makes sense because you outlined the important topics to think about how much to give away. Talking about investment, I also want to address the topic of term sheets. When founders get their first ones, they're usually very excited and they want to sign it right away because finally, at least for now, the money problem is solved and they can go execute again. But there are some specific terms that are really important to A, understand, and to B, probably also negotiate to make sure they don't bite you later down the road. What are some key terms that you always focus on with term sheets from investors?
Well, first of all, I would say two things. It's not a good idea to sign a term sheet right away. Let it settle at least overnight and show it to someone who's already seen a few term sheets. Secondly, when you sign the term sheet, you're not going to get the money right away. The term sheet is basically a summary of the contractual framework to come, and that will have to be negotiated. The thing with term sheets, and I understand that it's exciting if somebody is interested in what you've created over the last few years. It's flattering in a way.
Yeah.
But keep in mind, at the end of the day, it's a business transaction. Whatever is signed in a term sheet, while it's not binding for the largest part yet, is very hard to get rid of in the negotiations later on. You need very, very good reasoning to tell your counterparty, hey, actually, we started off from the wrong idea in the term sheet. So, because then they can do the same, right? So what I would do, that will probably be the most valuable thing I say today. Go to your lawyer with the term sheet. They've seen a lot of them, and they will probably add some of the things you didn't think about, and they will prevent some of the mistakes that can be costly. There's a few things that I would pay attention to. One is definitely, jurisdiction and applicable law, because if it's not, we're talking Swiss enterprises here, so it's not bought under Swiss law. If it's US law or UK, then you need another lawyer, obviously. So make sure, and most Swiss entrepreneurs are familiar with, let's say, the scope of Swiss law, so they will want that. Secondly, I would also address rather early on what are the liabilities. You're going to give representations and warranties. That's usually, at least on a level of topics, is a standard catalog. Then the wording is more something for the SPA in the end. But are you going to be liable with the whole purchase price? Is it going to be 50? Is it going to be 20%? I would discuss that, because that's a big decision, and it's always a difficult one in the contract.
What's your recommendation there? How much you should be liable for?
Definitely not for the whole purchase price. I think it keeps changing, but what we see these days is usually somewhere between 10 and 50%, depending on the company. Sometimes it's more buyer friendly, then it goes up. Sometimes more seller friendly, and then it depends also on how risky the business is, of course. The other thing that I don't like is like too many special indemnities. I think it's fairly standard to have a good catalog of representations and warranties, and then any additional indemnity needs to be well-founded with stuff that comes up in the due diligence that actually is a problem.
Yeah.
That's usually hard to address in a term sheet because it's usually before the due diligence. But I wouldn't sign anything off like there's going to be a lot of indemnities for everything. Yeah, I think that's pretty much the ones. Then obviously the price needs to be indivisible, but that's more of a commercial decision than a legal one. Usually I don't like earnouts as such, full stop, but then sometimes it makes sense, and sometimes you will have to agree to an earnout if you're selling. Don't do a complicated one, because that's lawyer fodder. That's stuff that it can be, again, depends on the counterparty, but it can be manipulated. There are loopholes. And
good example there is you want to focus on revenue, for example, instead of earnings.
Yes. or profits, then you're going to discuss line items and then is it above or below the line and all that. So, and some people come up with like real deal magician stuff, and that usually doesn't fly well in court. So keep it simple, and also, because the rules should be clear. And other than that, don't overload term sheets. I think you're in a fairly standard procedure anyways.
Hey, Swisspreneur listeners, did you know we have a monthly newsletter? That's right. On the first Friday of every month, we send out a digest with all the newest developments of the Swiss startup scene. From upcoming events to growth hacks and free resources to community stories and recent funding rounds. Click the link in the show notes to subscribe. You won't regret it.
And I know we talk about many different contracts and legal stuff. And always you do these agreements because you want to stay out of legal trouble. And often that works, not always. What do you do if you get hit by a lawsuit or a regulatory investigation or anything of that sort? Do you have like an action plan when this really happens?
Well, first of all, it's probably not good, not very helpful, but try and stay out of trouble. Usually, except for some really malicious circumstances, that will not come out of the blue.
Yeah.
It starts with make fair contracts when you can. This doesn't mean that they cannot be to your advantage, but don't make it as one-sided as to leave the other person no choice but to actually start looking for a way out. So that and then, when it's more like stuff that happens in day-to-day business, again, if you feel like this could be heading the wrong way, try and find another solution. And then I think it depends a lot on what the actual claim is, what the accusation is. When you talk about investigations, thank God that doesn't happen too often, definitely not to smaller companies. There's not, then you actually forced to cooperate to a large extent. There's some things you can do, you can, if it's a criminal investigation, you can have stuff sealed. In general, it's better to cooperate, I think. And then what the good news, especially if you get hit with a suit, is it's going to take time. It's good and bad. The bad is it's going to follow you for a long time, and you're probably going to create some sleepless nights and nightmares and horror scenarios. But you get used to it, after the initial shock. The other good news is Switzerland is not a very actor-friendly environment. It is always very hard to prove a claim. So I'd rather be on the defensive side and fending it off than actually trying to sue someone and get something out of it. That can be tricky. When you have time, it's usually also for the guy suing you, it's expensive. Mm-hmm. It takes time and energy. You have to pay the lawyers, the court fees, the advances. Very often, and I'd say I think it's about 80% of the times, it'll settle at some point. And unless you have a very, very good case, it's almost always more advisable to settle. Sometimes it takes time because on both sides there's usually a lot of emotion in it, a lot of ego, hurt feelings, and you name it. So that helps, and you get used to it. And then I would say very key is get a good legal assessment and analysis of your situation. How good is your case? But even then, meaning that you have good lawyers and a good assessment and even a good case, there's no guarantee you're going to prevail. Anything can really happen in court. I just read the quote the other day, at sea and in court, you're in God's hand. And it's true a bit. Obviously, some predictability is there, and there needs to be a way of resolving this. But very rarely is it advisable to drag it out to the very end, await the verdict. And keep in mind that like district court level in Switzerland usually takes a year or two. Then you go on to high court, same, a year or two, and if you go to federal court, so this can easily last for 5-6 years, and that's a lot of money and a lot of energy that is not really used for value creating, good entrepreneurial.
You can build another
stuff.
company in that
Exactly.
time.
So
it's crazy.
Yeah. So and a lot will also depend on the lawyer on the other side, and I think that can be a bit troublesome. Obviously, the lawyers, as you mentioned earlier, most of them are paid by the hour. So they have an interest in this thing going on for a long time. They're actually by law obliged to, represent and advise to the best interest of your client, which is usually not going to be to drag it out. So there's a bit of a conflict. But I think most lawyers are aware of that, and you can usually talk to one another and try and resolve things. But not all of them play for that team. Some of them are. So that can be difficult. But I would say it's important to keep some kind of communication open during that dispute, and that will usually lead to a quicker end, and again, better a quick death at some point, and have some cut your losses and move on than having this drag out forever. But yeah, I will also say sometimes it's necessary. It's not very often, but sometimes you have to stand your ground and go all the way.
In that context, often entrepreneurs are also thinking about their personal liabilities. Because one thing is, of course, the company, you have a lawsuit, whatever is happening there, it's the company. But to a certain degree, you as an entrepreneur, as a member of the board, as an executive of the company, you also face potentially personal liabilities. Can we also talk a bit more about those and how to make sure that you minimize that risk? Because that can really wipe you out also on a personal level if you're not careful enough.
Yeah, no, it's a big issue that comes up very often. The good news here is the law looks quite dangerous. As you said, personal liability by the letter of the law can happen relatively quickly, but in practice, it takes a lot for actually to stick. And usually, there has to be some kind of wrongdoing, which can happen, but then it also has to lead to a big financial damage, and there has to be causation in the middle, and to some extent also some fault. So, and to prove that, again, takes very long, and I'd say the percentage of, first of all, there's not that many lawsuits that are actually filed in that respect. It becomes a bit different in the case of bankruptcy, but other than that, it has to be like another shareholder usually that files that, or the company. So that doesn't happen too often in practice. You want to be careful about two things. One is definitely criminal exposure, which again, you have a lot of latitude in Switzerland. But I mean, what I will say is, be careful of what you sign. The one thing that will probably raise a lot of problems is like if you forge documents, sign something that is untrue, provide a wrong document or fraud, you state something that is not true. So that is not pleasant, that stuff, because again, that takes long and it's very hard to settle. That you're dealing with the general attorney and not with like a private counterpart. So that is the thing. And the other thing, it makes sense to sort of minute board decisions. You don't have to write whole transcripts and big pieces of paper, but when you get to a decision that is a bit risky, we have that thing called the business judgment rule. So you have a lot of latitude. It's not forbidden to make wrong decisions, but if you cannot document that you were careful, you exercise your duty of care and loyalty and all that, so then it can be a breach. So then you really want to make sure you write down what you were thinking, what was the reasoning, why did we decide that, and boom. So you can evidence that you did actually take a careful and educated decision. Also, what I wouldn't mess with is taxes and social security. Obviously, most of these kind of personal liability things is if you mess with social security payments, make sure they're always paid first, and same with the employees. So then I think you have a good chance of staying out of trouble.
Hopefully. That's also good to know what to focus on in that sense. All right, Stefan. So I have one last big question for you. If you could tattoo just one legal principle on every founder's forearm, what would it be?
Okay, I'm not sure you wanted to do that on the forearm, but I think maybe as a vademecum, like something you take with you and remember. I probably, and again, I'll resort to Latin again, is a pacta sunt servanda, which means contracts are to be fulfilled. So be careful what you commit to, orally and in writing, and especially in emails. So yeah, think twice about what promises you make, because people rely on it, and the whole legal system is based on that principle of trust. So yeah, and again, don't sign anything you don't understand or you're not absolutely sure you can live up to it.
Yeah. Do as you say, basically.
Do as you say.
I love
as simple
that.
as that. Yeah.
Now, to wrap up, Stefan, we have a few rapid fire questions.
All right.
I'm just going to ask you a question, and ideally you answer in one sentence, but I know sometimes it might take...
Hard for lawyers.
Exactly, I know. So the first question for you, what does money mean to you?
I'd say independence and the ability to do what you want to do, and the ability to do good, but also responsibility in a way.
What is one legal buzzword that is completely overused?
I'll give you two.
Cool, yeah.
Anything that is attached to sustainable has become very fashionable last year, and so many different meanings in it. So it's usually people raise heads and look around, but nobody really knows what it means in a certain context. So, and the other one is, I think, external investigations, which is another thing that has been inflationary as of late. And I think the perception in public is completely wrong, because by law, again, lawyers that do external investigations, they're accountable to whoever gives the job,
Of course.
You have to, again, take care of their interests. And so it's very, very unlikely that any of these results from an investigation are going to be more harmful than absolutely necessary. So
Yeah.
I think there's a false sense of security in there a lot, and usually some are better than others, but usually they're not worth much in my view.
It's a good management trick,
It's just,
I would say.
Yeah, it's a, like a diversion a bit.
Exactly.
And then you get somebody else to sort of white label you in a way. So yeah, yeah, but it has become quite frequent, sadly. Yeah.
What is a founder red flag that you spot within the first 10 minutes of a meeting?
Not having the business at heart, like if it's, in my experience, almost no one that started out with the goal to make a lot of money really made it big.
Yeah.
I think it's the other way around. If you're really in love with your business idea, you're convicted that it's going to do well, you actually persuade other persons to believe in your idea, and you live through it, through all highs and lows. Then, and then again, a lot of things have to be right for it to work. I always say is like, you need the good business idea, the good business model, whatever it is. You need the niche, the product. You need the right people that will stay the course and have the endurance, tenacity that you need to get where you are. And then you also need luck. And I think everybody who has been through that, who's made it, will admit that there's only so much. There's a lot of good business ideas and good business models with great people behind it. They were just too early or too late, or there's some other. So you don't have that luck element. So yeah, you need that as well. But if you just start out with the idea, let's hit it big, it's probably not gonna. And also, I think I have hardly seen people make it that didn't have good people skills in a way. It's obviously you always have different ones, like the proverbial nerd that is the best coder in the world. You need that in certain business models, obviously, but then you also need people to read other people, to negotiate, to talk to your employees, to talk to the other founders, to keep things together. So you want that as well.
Absolutely. Swiss precision or American hustle? What wins in business?
That's a good one. That's a very lawyerly answer. I think you need both. And in Swiss enterprises, very often, I think there is reluctance. We don't think big enough sometimes. We see a lot of problems, not that much opportunity. We're given, there's a variety of reasons for that, but how we all grow up, we're very security oriented. At the end of the day, I think it can create some great precision products. Take watches, for instance, or some of the mechanical stuff that we still do in this country, or pharma and all that. So it's good. But then again, I think when I look at the Anglo-Saxon part of the world, you have to take some risks eventually, and that's not our strong suit here in Switzerland. And very often people think, oh, that guy's nuts. Why is he doing that, taking that risk? And yes, more often than not, they'll be right to think that. But then again, you need these guys to take these risks so something can actually happen. Yeah. So, yeah, from a Swiss perspective, I think we need a bit more of that risk-taking and hustling, as you call it, to do more. But I will say it's gotten a lot better over the last few years. True. When I started out, it was a completely different landscape. Yeah.
We're on the right path.
Yeah, it's getting there.
And now this will be a very mean question for you, because you're involved in all three of them: law, restaurants, or watches, if you had to pick one.
I think they all have their place.
Yeah.
And obviously, if I had been able to pick one, I probably would have. So I've kept all of the threes to date. Yeah, the watches, I'm not that much involved anymore. And that I've never been too involved. I've never been really operational in that one. The other two, yes. I think I'm happy with the mix that I have. I devote most of my time to law because I really like doing it still. I don't necessarily enjoy all the management stuff that goes with it and all the administrative. Sometimes, it's long hours and very hectic schedule, but I like the actual work. I still do it. And the Hooters, the restaurants, is a good diversion, and it's more like a youth thing, as I said earlier. So I'm happy with one, but yeah, I hope I don't have to pick one. So
you continue with
I will
beautiful.
Yeah, exactly.
Absolutely. Those were all my questions, Stefan. Thank you so much for your time today and for your insights. It has been a pleasure having you on the show, and I wish you all the best and lots of success for the future.
Well, thank you very much. Thanks for the good questions, and hope it was helpful. Will be helpful to some of the people that listen. And yeah, all the best to you too. Thank you.
We hope you enjoyed today's episode. If you did, you can support us by rating our show on Apple Podcasts. This way, we can reach an ever-growing number of aspiring entrepreneurs.